Hi, Kirti, can I start?
Yeah.
Yes, sir, please go ahead.
Okay. Hello, everyone. Thank you very much for joining, today's webinar. We are very pleased to have two amazing speakers join us today, Dr. Pritpal Kaur Sidhu and Dr. Rajesh Gopalkar. Thank you so much, respective leaders, for joining us today and sharing with us. And we are blessed to have Dr. Pritpal again with us. She had spoken during one of our webinars last year also. She's very inspiring. And we are, again, very curious to learn from Dr. Gopalkar as well. But before we dive into today's topic, I wanted to share something about the importance of IPR for startup SMEs and researchers like yourself, and how one of our programs called L2 Pro can help you with. I am Dr. Hemang Shah. I work for Qualcomm, also the co-chairman of the National IPR Council at ASSOCHAM. So we are proud to bring this webinar for you, for your benefit. And again, very proud to have more than 6,200 learners that have taken this particular program. Now, as Qualcomm, we have been working with startups since 2016, and happy to share that since our program launch, we have worked with more than 125 plus startups in India, covering a variety of deep tech problems that they have solved. We have raised more than $300 million, and that will mentor them a lot is on IPR. Because I started this program, we saw that the IPR awareness, needed to come up, for every startup. So that's how this program was planned with the DPII and NLU Tech. What L2 Pro does is helps in increasing our awareness around IPR, particularly how to protect your innovation through patents. And as we'll learn today, how copyrights can help.
Hemang, you are not that clear. Is there a way you could kind of, I mean, like your voice is kind of fading in and out. We are able to hear you well, though.
Okay, this is some kind of. Does this help at all? Because
a little bit.
Okay. Thanks, Anupam. We learned later today how copyright can help other IPRs, such as your software, how trademarks and other IP considerations should be thought of. Most importantly, as innovators, you need to bring your innovations quickly to the market, right? So, how we provide this information is of utmost importance to you. The way this material has been presented is in three levels. In my opinion, everyone, regardless of the profession, should be familiar with the basic level. Okay, I guess there are still some issues. I what's the Anupam, you might cover it for me because I don't have a mic handy over here. Let me dig it up. Maybe we can cover the rest. Like,
should I, Hemang? Should I cover the speaker introductions? Yes. Okay. Yeah. Good afternoon to all attendees. And as Dr. Hemang Shah has said, L2 Pro is our IP training e-learning program. I just pasted the link on the website, and I'm very happy to to start the proceedings of this webinar, which is the L2 Pro workshop on copyright protection and strategy for startups and MSME. We have two very eminent speakers. Really very happy to introduce them. Uh, so first I will introduce Dr. Prithpal Kaur Sidhu, who is the Deputy Registrar and Head of the Copyright Office. Dr. Prithpal Kaur Sidhu is successfully completed an advanced course from WIPO on trademarks, copyright, and arbitration law. She has written 2 books on the rights of persons with special abilities under the Disability Act. She has published more than 100 research papers in national and international journals. She is presently head of office of the Copyright Office, chairman of the Copyright Amendment Act, and she is involved in various policy decisions at national and international levels in trademarks and copyright law at WIPO. Our second speaker is Dr. Ragini P. Kubalkar. She is the, uh, the DPIIT chair professor at MNLU Nagpur. Uh, she has done her PhD on the topic of copyright law, national and international perspectives after completing her LLB course. She did her LLM in commercial laws in addition to her simultaneous post-graduation in MA economics. She did her LLM intellectual property laws in 2007. She has cleared the national eligibility test in law conducted by UGC in 2009. Before joining MNLU Nagpur, Dr. Ragini had worked as an assistant professor of law at GWCL Nagpur, affiliated to the RTMNU Nagpur from 2010 to 2016. Since November 2016, she has joined the prestigious Maharashtra National Law University Nagpur as assistant professor of law. She has worked as member convener of coordination committee for WIPO India Summer School 2017, 18, 19, 21 and 22. She has delivered numerous lectures as resource persons and acted as judge for various conferences, seminars, debate, and moot competitions. I'm really privileged to welcome Dr. Prithpal Kaur Sidhu and Dr. Ragini P. Kubalkar to this webinar. Uh, Honorable speakers, you have about 20 minutes for your lecture, and then we will have 10 minutes. So the total webinar is about an hour's duration, and we always have a very engaged audience. Let me just tell you, actually, I have the privilege of telling you that we right now have 130 attendees to this. So you can imagine your popularity. This is actually the highest we have seen in many years, actually. I will tell you, in a year's time, we have not seen so many attendees. So I do hope you are encouraged by the audience, by the number of audience, and they will also have, they will have a good, they will learn a lot from you. Thank you so much. And Dr. Prithpal Kaur, now the floor is up to you. Thank you so much.
Thank you, sir. Thank you so much.
Yeah.
Thank you, SHM, for inviting me and giving me the opportunity to present my views. I've given a duty to present to you. So, is it visible, Parul?
Not yet, ma'am.
Yes, ma'am. Your slide is not visible. If you share, then I'll let you know.
It's not visible. That's
yes,
visible.
it is visible now.
Yes.
It is
No,
visible.
madam, it is.
It's
It
coming.
is visible.
Yes,
yeah,
ma'am.
it has come up.
It's visible.
Yes,
ma'am.
ma'am. Yes, ma'am. Go
you
ahead,
can
ma'am. Yes.
Thank you. Today, I am going to discuss on the topic copyright protection and strategies for startups and MSMEs. I will cover what is the copyright, what is the significance, what is the importance, and what are the challenges and benefits of copyright, and what are the global best practices in terms of modernization of copyright, and what are the copyright infringement and enforcement. All we will discuss in this. First of all, regarding the introduction part, The word copyright is a mixture of two words, copy and right. It is a type of intellectual property protection governed under the Indian Copyright Act 1957. IP refers to creation of the minds, such as inventions, literary and artistic works, designs and symbols, names, images used in commerce. However, the term is
Ma'am, I'm really sorry to interrupt you. Is it possible for you to put it in full screen mode, ma'am, so that
yes.
people are able to see it, ma'am? That would be very helpful.
Now it's fine. Now it's fine, sir.
No, it has not yet come, ma'am, for some reason. But if,
Actually, I have put it in a
okay, ma'am, please continue, ma'am. Please continue. I'm sure. Yeah.
Unmute हो. Family दो.
what startup is basically. Startup is defined as an organization to develop a repeatedly and scalable business model. That is a startup. And if we talked about the MSME, that is micro, small, and medium enterprise, it is an independently owned and operated enterprise designed for profit and sells known products to known customers in local market. If we talked about startups and MSME, these are the backbones of economies of the worldwide. They are also known for their innovation, creativity, and agility in responding to market demands. They are very important, startups and MSMEs. In this digital age, if we are talking about protecting intellectual property is a paramount. Thereafter, intellectual property, including copyright, plays a very important role in the success and growth of these businesses. Copyright protection can benefit startups and MSMEs and provide strategies to secure their creative assets, their operations, and growth. If we talk about today's world in a competitive business environment, it is very common for the competitors to try to replicate successful products, content, or branding. Therefore, it is very important for the copyright empowers startups and MSMEs to take legal action against copycats, protecting their market position. That is the most important thing we are facing these days. What is copyright basically? Copyright is a legal concept that grants creators and authors exclusive rights to their original creative works. That is a copyright. Copyright basically works at that includes different categories. Is there any problem?
Ma'am, please continue speaking. Unfortunately, there are people who have their mics on, so there will be some disturbance. I'm requesting Parul and Kirti from ASSOCHAM to mute people.
Sure, sir.
Mute
We are
people in the audience.
sure, sir.
Yeah.
Work
Ma'am,
includes,
please continue speaking.
yes, please. Work includes different types of categories of work, that is a literary work, artistic work, musical, and other forms of intellectual property. In copyright, we have different types of works, and we have a different fee characters for a literary work. Like we have 500 fee for artistic work. If it is a simple artistic work, then we have 500 rupees. But if you take NOC from the trademarks, that is for 2000 rupees. These are different categories of work we are handling under the copyright, and you can file a copyright. Under the Copyright Act 1957 guarantees certain safeguards with regard to the rights of the authors over the creation made by them. We can see that no civilized society can ignore the essential requirement of encouraging creativity, as it is a keystone of progress in society. Additionally, the social and economic development of a society is majorly dependent on creativity. It ensures that creators have the right to control how the creations are used, how that is distributed, how that is reproduced, allowing them to the benefit financially and maintain creative control over their work. It is their prerogative, it is their right. Any other person who copies the original work of the author or creator will be liable for the copyright infringement. as per the provisions laid down in Copyright Act 1957. The protection provided by the Copyright Act 1957 to the hard work or the efforts of the designers, writers, artists, musicians, dramatists, architects, and producers of cinematographic films, sound recording, computer softwares. Computer software also covers under the copyright, creates an encouraging creativity atmosphere for them, which also encourages them to create or generate more and also motivate others to create such works. That should be the copyright. In contrast, the creation created by the creator cannot be claimed for ownership for generations. There should be some limit, as will be harmful to the social justice. That is why under the Copyright Act, there is a provision given for the purpose of determining the time period that is given under the Copyright Act for protection adopted in India, a term of life, author or creator. That is in addition to 60 years. It means lifetime plus 60 years it can be provided. However, it may vary from country to country. If there is a rapid or rigid application of copyright protection in a country, it can affect the progress of the society. Thus, in a country, copyright laws enacted with certain necessary exceptions and limitations, which are very, very essential to ensure that a balance is maintained between the interest of the creators and the community. That is the most important thing. We have to maintain a balance. Now, coming to what can be copyrighted, these are different categories where you can take the copyright protection. Under Copyright Act 1957, protection is provided to the hard work or efforts of such workers in order to create an encouraging creativity atmosphere for the creators, which also encourages them to create or generate more and also motivate others to create such works. These are the different categories you can take: literary work, dramatic, choreographic, graphic, motion pictures, sound recording. Most of the people think to copyright that is for the literary work only. No, it is not only for the literary work. It is for musical work also, it is for pantomime also, pictorial work also, sculptures that can also be copyrighted, audiovisual work, architectural work. If it is not registered under the Design Act, that can be protected under copyright. These are few of the examples I have given. Copyright Office has basically streamlined the registration process. Now, Copyright Office has introduced a user-friendly online registration system, reducing processes timelines and making it easier for the creators to register their work. This has led to a significant increase in timely registrations and enhanced copyright protection. It provides legal proof of ownership. It gives a sole right of usage. The owner can earn extra funds by licensing their work to others, and the owner of a copyright has a sole right to decide who gets to use the work and to what extent they can use their work. Right? What are the main documents we are facing? The Copyright Office is facing the problem regarding the registration. People are not filing the appropriate documents basically. No doubt copyright is an automatic right, but at the time of registration you have to submit certain documents on the basis of which we can scrutinize your application and we can process further. These are the few documents. First of all, IP or demand draft for submitting applicable fees. In this, people are facing the problem. They don't know which one is the artistic. There are two types of categories of artistic work. One is under the 500 category and other is a 2000 category. It's a very simple thing. If we are using for the goods and services, that comes under 2000 category artistic work, and you have to take a NOC from the trademark registry. But if you are not using for the commercial purpose or goods and services, then you have to take 500. You file the registration under 500 category, and you get the copyright. We are basically issuing the discrepancy letter in this only. Please submit your deficiency fee. This falls under this. You have to file the NOC. This is a major problem Copyright Office is facing. People don't know कि artistic जो work है that falls under which category, 500 or 2000, right? Second is NOC from the real owner. A power of attorney in case if the attorney filed the application. NOC of the person who wishes to publish his or her photos on the work. That these all are the relevant documents you have to submit at the time of filing of the registration process. We have now we have introduced an automatic registration certificate also, and we have given a link under your user login and password. You can download if you have received the email but you forget to see that. But after that, after a few days also, you can log in and you can download all your certificates from in a one go. That is a link we have given recently. Now it is automatic registration certificate is issued to you. There are different types of forms available for the filing. There are 4 types of forms. For the filing, it is only form 14, right? Form 14, application form for registration of copyright, that is a form 14. Application form for registration of changes in particular of copyright. Changes in particular means if you want to do the assignment, if you want to change the name, if you want to assign anything, then you have to file a form 15 in this. Application for the relinquishment, there is a form 1. If you want to relinquish your right, then you have to submit a form 1. It's a very simple form for filing the form 14. Form 14 is a very simple form for the registration process, right? This is the copyright registration flow. First of all, you have to file a application along with the fee. Then office issues you the diary number. We have to wait 30 days mandatory period for the objection. If anybody wants to object the application, that is also given under the on a website stating fresh application. If you want to file any objection petition, then within 30 days you have to file a objection petition. If objection petition is filed, then it goes in hearing. But if no objection is filed, then it is scrutinized by the examiner, and the examination means discrepancy letter. If there is any discrepancy, we will issue the discrepancy letter. If there is no discrepancy, then it goes for approval and we will issue the registration certificate. But if there is a third party objection, then in that case both the parties office send the hearing notices and they have to file a reply. If they have filed a reply that is satisfactory, then on that basis also registrar can decide the case. But if the registrar is not satisfied with the reply, then the application goes in hearing, and at the time of hearing it is decided on the merit of the case, right? This is the copyright registration workflow. What are the challenges and benefits of copyright? There are different challenges we are facing and benefits also. Complexity and duration. The law can be complex and varies from country to country. Additionally, the duration of copyright protection is often quite long, typically the life of the author plus 60 years, which hinders the availability of creative works in the public domain, right? Next one is a fair use and balancing rights. Determining what constitutes fair use or fair dealing can be a challenge, as striking a balance between creators' rights and public access to information and culture is a difficult task. Another challenge which Copyright Office is facing, enforcement costs. It can be expensive and time consuming, making it challenging for the individuals and small business to protect their rights effectively. Digital challenge is another challenge, which brings new challenges such as online piracy, which can be difficult to combat effectively as it is a widespread and often hard to track and stop. These are the few challenges. Abuse of copyright claims, access to knowledge. Some copyright holders misuse copyright claims to stifle criticism, competition, or free expression. This can result in copyright trolling and unjust legal threats. These are the benefits of copyright if you get the registration. Protection of creative works. It provides a legal means to protect creative original works. It encourages them to produce and share their creativity without fear of unauthorized copying. Financial incentive also. Economic benefit is there. Preservation of culture. It protects traditional and indigenous knowledge and works from exploitation and misappropriation. Licensing opportunities also are given. Public domain, moral right. If you're talking about moral right, it also creates to protect the integrity of their works and receive attributions, which can be crucial for their professional reputation. Another benefit, deterrent against plagiarism. How we can control plagiarism. It is a deterrent against plagiarism and unauthorized use of others' work, promoting ethical behavior in a creative and academic fields. These are the benefits of copyright. What is the significance of copyright for startups and MSMEs? These are some of the significance, or you can say that main objectives for startups and MSMEs. Protecting intellectual property. I'm not going into the details. I think I am having a very limited time. Protecting intellectual property for startups and MSME that heavily rely on intellectual property. It safeguards the original creative works such as software code, product design, marketing material, right, and content from unauthorized use or replication. Competitive advantage, that is also a main significance. The protection helps startups and MSMEs to establish a competitive edge by preventing competitors from copying or reproducing their innovative content or products. This can be specifically crucial in markets with similar offerings. Attractive investment, licensing opportunities, enhancing brand value. That is also very important. Copyrighted logos, branding materials, and marketing collateral can enhance a company's brand value and helps maintain the integrity and reputation of the brand. It should be a global expansion. It is also advantageous for the startups and MSMEs looking to expand their market presence beyond their home country, as it is recognized internationally through treaties and conventions. Right? Marketing and promotion, retaining controls, easier enforcement, cultural and creative industries, and preventing reverse engineering. These are some of the significant points for the startups and MSMEs. Software and data is a copyright for technology. It is also protected in the field of technology. The subject of software data both falls under the umbrella of copyright protection. However, they are distinct forms of intellectual property. Copyright protection जो है, that is given for the software typically lasts for life of the author plus 70 years in most countries. But this duration may vary from country to country, right? I'm not going into the details. These are some of the, this is very important, global best practices in terms of modernization of copyright. Different countries are following, this is globally accepted. These are the few best global practices I'm sharing with you. Fair use or fair dealing. Many countries have adopted fair use or fair dealing provisions that provide a framework for assessing whether a particular use of copyright material is fair and legal. This approach allows for more nuanced and context-specific decisions. Digital right management and technology process measures, like DRM and TPMs. Copyright laws may address DRMs and TPMs to ensure that they do not unduly restrict legitimate uses of digital content while still protecting against copyright infringement. Notice and takedown procedures. To address online copyright infringement, modern copyright laws often include provisions for notice and takedown procedures, which allows copyright holders to request the removal of infringing content from online platforms. These are few best global practices I'm discussing. Safe harbors for
Dr.
internet service
Pitpal,
providers. Yes.
please don't mind if you can, if you can close in 5 minutes
Yes,
because
please.
the webinar
Yes,
is for
please.
an hour. Thank you so much.
Right. Public domain and open licensing, cross-border licensing and collective management often works, and I'm not going into the detail because of the shortage of time. Open access and open education resource, these are few of the best practices we are adopting. I think you all know what are the punishments and fine under the Copyright Act section 63 talks about that. I'm not going into the details. These are some of the few civil remedies. Criminal remedies are also given, right? Just to conclude my presentation, I would like to say that copyright is a strategic tool that helps startups and MSMEs protect their intellectual property, attract investments, defend against competitors, generate revenue, and build a strong brand presence. It is a critical component of an intellectual property strategy that can contribute to the long-term success and sustainability of these businesses. It offers important protections and incentive for creators and business, but also present challenges related to the complexity, enforcement, and potential for use. Modernization copyright law is an ongoing process, and best practice continue to evolve as technology and societal needs change. Countries often look to the experiences and innovation of others to inform their own copyright reforms while considering their unique cultural and legal context. Thank you so much.
Thank you so much, Dr. Pitpal Kaushittu. Attendees are requested to post their questions in the chat box. And now I would request Dr. Ragini Kubalkar to make her presentation. Thank you so much, Dr. Ragini.
Thank you, sir. Thank you so much. First of all, I extend my thanks to Ascertain for inviting me to interact with so many participants and to connect with Copyright Registry Office too. I'm really happy to share the platform with ma'am and you people also. So I'm sharing my PPT so that it will be visible to all. Yes, I think it is visible.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Ma'am,
Yes.
please put it on full screen mode, ma'am.
Yes, I'm doing that.
Yeah, it is. Yes.
Is it?
Now it is on full screen mode. Yes.
Yes. So, dear participants, today I'm going to talk about copyright protection and strategies for startup and micro, small, and medium enterprises. Half of the work, or more than half of the work, has been done by my great
Dr.
colleague, yes, Dr. Prithva Kaur ma'am. So thank you for that. I'm going to cover some of the points. There may be some repetition might be there, but I will be focusing on certain aspect which we have to understand as a concept. If those concepts are clear in our mind, then what will happen automatically while starting our any business, small or anything, we will be in a position to identify that we should not be faced with some certain infringement cases, or our work should also be protected. So when we are talking about copyright, the first and foremost thing which we have to understand that we have to see certain important provisions of Copyright Act of 1957. Okay, though we are not a part of, we have not done that as our regular coursework or any degree work, but certain provisions we should have clear understanding about it, or you can attend certain programs or YouTube videos are also available which help you to understand what copyright law is, and key understanding about it will help you to overcome certain problems at the initial stage itself. So when we are talking about this Copyright Act of 1957, first we have to understand that it protects 6 categories of work: literary, artistic, dramatic, musical work, cinematograph film, and sound recording. These are the 6 categories of work. So if our startup is with respect to any of these work, or it is going to interconnect with somebody else's work, so we have to be little bit alert, and we have to see the definition part of section 2 of this act, which help us to understand what is exactly literary work. Ma'am has covered what includes in literary work, dramatic work, artistic work. But again and again, you will be required to visit all those definition part, which is there under section 2 of the Copyright Act. It helps you to understand what are those other sub part which has been covered under this work. That is the first thing. Then you can see that it says original work. Original work, that again, that originality is attached to 4 type of work, that is literary, dramatic, artistic, and musical work. So see, copyright law is not specifically saying that copy work should be registered. That is not compulsory. But we have to remember that whenever there is certain dispute is going to be arise in future, this registration is going to help us to prove our claim very easily. And for that matter, copyright law has come up with this registration procedure also. Flexibility has been provided to us by this act. It is not compulsory, but being from legal point of view, I am sharing with you that it's always better that our work should be protected. And if we have document, it is easy to prove that this work belongs to me. So in case of future infringement cases, you will be having documentary evidence. Okay. But apart from that, if you are not doing that procedure, that is also fine, because copyright law says that on the point of creation of these 6 type of work, you will be having right into that. Copyright will be there. And section 14 of the act has given certain rights with respect to different types of work. Okay, so you can see that when it comes to literary work, okay, if you are using some artistic work, what are the rights available to that particular owner of the artistic work? You should, or we should have clear idea about it, so that there will not be infringement from our point also. And if we are creating some artistic work, we will be having idea that what are those rights assigned to artistic work. Okay, so that will clear by section 14 of the act. So remember, section 14, you have to read it out. Okay, and you can see number of videos on it. That will help you to avoid litigation. Okay, so if it is artistic work and we are designing some dress, for example, okay, or dress designing, that is what you are, you want to be in that particular, or fashion designing, that is what you want to start with your business. So you should have clear idea that whether you are allowed to copy the designs of the dresses which are available on internet, because nowadays we are continuously accessing everything on internet. So we should remember, first thing is that whatever available on the internet, it is not freely available. Freely available means we are not supposed to copy it. Okay, just like that, in physical form, when books are available or in books designs are available, we are not supposed to copy it. In the same manner, if it is available in digital form, it does not give us right to copy that and apply that design to our work. Okay, so we have to be very careful when we are talking about copyright law. See, though copyright law is not saying that you may not register your work, but it says that on creation of the work, copyright is there. Automatic copyright is there. So we have to remember that. Okay, the other thing is that Other thing is that please mute yourself, otherwise my link is going to be disturbed and whatever I want to convey you, that may be missed out. Yes. So other thing is that when we are starting with any business, these are the important things which we have to keep in our mind. Apart from that, section 14 talks about what are the various rights available to us. Okay. And when we are entering into business, being an entrepreneur, we have to see that we have to secure all those rights. And that security can be possible only if you are aware of those rights. If you know that certain logo you are putting on your business, that may be business of goods or services, whatever business you want to start with. Okay, so if you want to start with your name or initials of your name, or two members or friends are there and they are deciding that we will start that particular business. So what you are doing, you are putting your mind, your intellect into creation of that particular logo or that particular name which you want to give to that business. That is what, that is your original expression of idea. Everybody has idea that we have to give certain name to our business, because you never knows which type of form it is going to take, right? You must be read about Disney theme park. When that business was started with public theme park, they were not having idea that they will be having different types of IP, and that business will reaches, means everybody will knows about it, and economy is going to be boosted by because of that startup. Nobody was knowing at that particular point. So we also should have that that kind of understanding about our business. And see, if your mark or name, whichever you are going to put with your business, if that is very attractive, okay, it is going to be copied by someone. So see, there are different types of IP which will be over there. If you are going to register it as a trademark, then different set of rules and regulation will be applicable. But when you are innovating something, creating something and putting it on paper, you have to remember that it's better to register itself. And again, I am repeating, if you are not registering it, then also you have all those right to copy, right to make reproduction of it, right to disseminate, right to communicate it to the public at large, right to translate it from one form to another form. And with that translation also, you have number of rights. Like you must be knowing 3 Idiots, the book 3 Idiots movie, which has been made on the book of Chetan Bhagat. So you can see that when we are talking about one literary work, we have number of rights available to that particular work. So when we are talking about copyright, it's a bundle of rights we are talking about. And being a startup, we should have clear idea, not for safeguarding our business, but not infringing anybody else's business. And you have to see that this act is talking not only about civil remedies, it's talking about criminal remedies are also there. That is what ma'am has covered. So we have to be very vigilant. Just like we know that whenever we are talking about crime, everybody knows about IPC, Indian Penal Code. Theft क्या होता है, copy क्या होता है, cruelty क्या है. We know in general. We know in general, not necessary. We know legally contents क्या है, definition क्या है. But in general, we know that we are not supposed to steal somebody's some goods, right? In that way, when we are talking about copyright, we have to remember that we are not supposed to copy somebody's work. In that general understanding, you have to read section 14. Then these rights make us economic use of out of that particular work. And this is the general reading which I have taken from WIPO website. So you can also have access to it. And they have given general outline with respect to startups. Whenever we are starting with, what are the general guidelines. So you can see over here the time period for protection of copyright has been mentioned. In certain cases 50 years and certain cases 60 years. India is protecting the work for 60 years. When it comes to literary, dramatic, musical and artistic work, it is protected for lifetime of the author, the person who creates it. Apart from that, it is protected for more after his death, after death of the author, from next calendar year, more 60 years, work is protected. So whenever we are using certain work of anybody else, okay, we have to remember that that work is protected under copyright law. So we are not able to copy it, reproduce it without the permission of the author, or if author is not there, without the permission of legal heirs. Okay, up to next 60 years. And that is why you must have read about the Nazma Heftullah's case, who was claiming about royalty and other things. Okay, so remember this period is very long. When it comes to patent, 20 years. Design means it's renewable, trademark renewable. But when it comes to copyright, long time period is given for the protection of various different types of work. Okay, apart from that, one more thing we have to remember, that moral rights are also attached to these different type of work. Moral rights, that is right to reputation, right to paternity and integrity. That is what's stated. Reputation means we are not supposed to infringe. We are not supposed to use or make changes in any existing work. And integrity means my name should be attached to that particular work. In that way, two moral rights are also given under copyright law itself. Okay, the provisions are already there. I'm not going into depth with all the provisions, but here I just want to inform you quickly that these are the very important things which we should have keep in our mind when it comes to copyright law. Computer program. Computer program itself is protected under copyright law. Okay, because when we are writing computer program, we have to write it in certain language. But when that computer program is a part of some technology, okay, and it solves some technical problem, then that will become a part of patent protection. Okay, so this technological advancement also should be very clear in our mind. So if anybody wants to start with their developing computer software, then we have to remember that if you want to protect it independently, computer program per se, that is the wording in law, then that will be protected under copyright. But if it is a part of some hardware, you are putting it into some hardware, then it will be a part of patent. Okay. Then strategies and all, ma'am has already covered about it. So I'm not going into detail. Yes, she has covered the best practices also with respect to startups. So we have to be very alert on these points, whichever points has been covered by it. And whenever we are putting some mark or using certain information or writing something, you never knows how that is going to achieve which status and how they are going to use very frequently or very easily. Okay, and therefore registration of work is the best policy which I can ensure you in your future startup. Okay, then yes, there are number of other businesses also. When you are giving license to somebody with respect to your work, okay, at that time also you should be have a good idea with respect to law of contract. Okay, because contractual agreement are going to help you to decide what rights you have and what are the infringement and what will be the consequences of it. Okay, and then yes, you have to start, before starting your business, you have to search database and you have to find out what are the work which is already copyrighted. Okay, so registration of copyright, one thing. duration of copyright, we have to remember in our mind amendments, whichever rules and regulations Copyright Registry Board is continuously making. We should have update knowledge about it. Okay, that much understanding we should have. Then we should have fair dealing also, how much part we can use, and that will not be called as infringement. Like if I am using this image from Google, okay, but this is for awareness, creating awareness, for research work, for education work. If I'm doing this and copying it for education purpose, then that will not amount to infringement of copyright. It will be protected. For that matter, again, you have to refer section 51 and section 52 of the Copyright Act. Okay. So when we are talking about startup, infringement issues are there, strategies for startups, we have to make all strategies in advance, because it's a volatile concept. Then whenever we are talking about intellectual property, we are talking about volatile concept, and because of that, we cannot fix the value of our business at this particular point of time. And therefore, we have to have certain knowledge with respect to copyright law also. Thank you all for your precious time and patiently hearing. Now floor is open for question answer session. Over to you, sir. Thank you.
Thank you so much, Dr. Ragini. It was a very engaging session, and we actually have lots of questions. I mean, as I told you earlier, we at one point we had about 180 people attending it, and now also there are still, even though we are almost at the end of time, we still have a lot of people. So I have actually noted down all the questions, and I will ask. I'll ask them. So one question is from Mr. Harpreet Singh, which I will answer. What are the differences between copyright, trademarks, and patents, and when should each be considered for protection? Mr. Harpreet Singh, I would be very grateful if you took up the L2 Pro e-learning program. The first lesson itself will tell you about this. So this is not, we will not take this question. Okay. Then the second question is from Dr. Milind Nisargandha. He asked, which work comes under artistic and literature work? So Dr. Pitpal and Dr. Ragini, I don't mind, any of you can answer this question. Dr. Pitpal, you're under mute. So, okay, Dr. Ragini, you can answer.
Yes, sir, please repeat the question.
Artistic which comes under artistic and literature work?
Okay, see, for that matter, you can go to the definition part. If we are writing something, literary work is written, okay, and you can see the definition. I'm reading definition for you. Just give me a minute. Okay. Yes, it says when it comes to artistic work. Just a minute, I'm missing somewhere. Yes, it means they have given examples: painting, sculpture, drawing, diagram, map, chart, plan, engraving, photograph, whether or not any such work possesses artistic quality. That will be covered under artistic work. It means that they are not asking about quality. Copyright law is not at all on on quality of the work, but they are just saying that if you have expressed your ideas in any form, that will be protected under copyright law. And in that way, they are saying that if we are talking about this expression of any type of work, that is painting, sculpture, that will be protected. And here I just want to give you one very funny example, and everybody must be knowing. Most of you must have seen Welcome 3, where Anil Kapoor has made one drawing, and donkey and horse, that picture is there. That is means quality. When it comes to quality, nothing is there, but still it is protected under copyright law. So that is what we have to understand, that whenever we are talking about copyright law, it says that if you have expressed your original thought, your ideas by using information, knowledge which you have, that is a subject matter to be protected under copyright law. Okay, and literary work means anything in return. If we have done that, that will be protected under copyright.
Okay. Ma'am, we'll just very quickly go through the questions. One very interesting question, of course, and I think we have the answer for it, but still I'll ask. Does a copyright registered in India automatically gets international protection under Berne Convention? If so, is it for the same protection term of 60 years plus lifetime? What are the applications of copyright in new venture and at what stage they normally come up in the journey of a typical startup? So this is from somebody who has identified himself as consultant. Yeah.
Okay, ma'am is a better authority.
Dr. Principalji, if you could just unmute yourself. You're on mute, ma'am. Ma'am, you're on mute. You have to unmute yourself. Ma'am, you were unmuted now again. It's mute. Yeah. Oh,
No doubt copyright जो registration है, that is an automatic right. But just as ma'am told that कि अगर हम उसकी protection करा देते, then only we can sue to the other person. Otherwise we cannot. No doubt. जैसे for example मैंने if I have written a book or I have taken an artistic work, ठीक है? That is my right. That is my original work, right? But अगर उसको कोई copy कर रहा है, that is my automatic right. But उसको कोई copy कर रहा है, how I can protect? How I can say that I have registration, right? तो उसके लिए आपको registration कराना, that is compulsory. No doubt it is an automatic right. I have told in my presentation also कि it is an automatic right, but आपको दूसरे को sue करने के लिए दूसरे को, if anybody infringes your right, then you have to take a registration for that.
Ma'am, they are asking about international protection, ma'am. If you can just speak about that. Ma'am, you're on mute, ma'am. You can unmute yourself. Dr. Ragini, can you take the question on international protection?
Yes, when it comes to international protection, we have to apply it just in a separate application. Automatic protection cannot be granted. Okay, international application we have to file. Okay, and then only we have to identify in which countries we want to get protection, and everything will be done by the office itself. I think ma'am wants to. Yes.
There is some technical problem issue in this. In this, if anybody wants the international registration, then they have to file in their domestic law according to that. Recently, I have received the application for Japan. Japanese want to file an application, want a registration in our country. They have Japan has given the NOC कि they can apply in our country, but उसको जहाँ पे भी मतलब in different countries if you want to file, then वहाँ की उनको domestic law के accordingly they have to file the registration. That is not automatic. Automatic doesn't mean कि आपको registration मिल गया automatic का. Automatic means that is your original work. People confuse in that, right? Automatic means if I have written something, if I have created something, that is my right only. Nobody can claim on that. But if anybody infringes that, then if I am having a registration, only then only I can sue that. लोग सोचते हैं कि that is an automatic right, मुझे दूसरी countries में भी मिल गया. That is an automatic right, मुझे India में भी मिल गया. That is not the case, right? That is based on the originality. If that is not automatic, जो आप क्वेश्चन आपने पूछा कि automatically वो दूसरी country में उसको मिल जाएगा या नहीं? No, they have to. he or she has to apply there
Okay.
according to the domestic law.
Ma'am, Mr. Gulab Bhai Rohit, he's asking copyright laws are different or linked between CRPC and Contracts Act.
Yes, sir.
Yeah.
Yes, it is different from CRPC and contract, but see, these are the basic laws which governs our actions. So when it comes to civil remedy, it is not this special act is going to regulate everything. Okay, at that time, what procedure to be followed in case of civil dispute? For that matter, we have to take shelter of civil procedure code. Means how proceedings will take place. If it is a criminal remedy we are talking about, which has been provided under copyright law, then also we have to see what are the criminal procedure to be followed by the court. Okay, when we are talking about license, assignment, or transferring our rights to anybody, okay, at that particular time, or assigning our complete copyright to anybody at that particular time, we have to write down certain things. That much everybody knows. That is known as agreement between two parties. So whenever we are talking about those agreements, it is going to be regulated by law of contract. So we are not supposed to understand all these things in.
Can we go out to?
Okay, we have
Kindly
to
mute
see
yourself,
that
people.
whenever we are talking about copyright infringement, these laws are automatically comes into picture. Yes.
Ma'am, we have a question, I mean, a very quick question from Dr. Ruby Chatpal. How do I get copyright for my article published in the international journal? Maybe any of you can take the question.
You just have to fill a form 14.
Okay. Form 14. Okay.
Form 14, you have to give that is your original work, title and your article. You have to fill a form 14. There are three main columns, 2, 7 and 11. That should be the compulsory one. उसमें आपको ध्यान रखना है कि that should be your original work and title should be there and it should match your जब आप फॉर्म भरते हैं फॉर्म में and जो आप वर्क दे रहे हैं that should be the same title. Right?
Okay, ma'am. Ma'am, we have got a question from Dr. Milind Nisarganda. I'm not understanding the question very well, but I'm going to read it out. And Dr. Milind, if you want to ask a question, you can ask it yourself. He asked how to reply to the discrepancy when they mention the name of authors of work in column number 7.
I have already write down in a chat box, sir. If you want to file a reply for the discrepancy letter, then from your copyright user login, you can upload your reply in that. Because in copyright, we cannot put everything in public domain because there are some unpublished work also. So that is on the basis of the user login, you can log in your account and upload your reply. There is a button given, upload the reply that is given for your discrepancy letter. You can upload directly from that.
Okay. So then somebody is asking what is the difference between copyright the logo or trademark the logo? So somebody is asking this question, ma'am.
Copyright is for the simple. If I am talking about the layman's language, it is an artistic work. That should be the artistic work, right?
Right.
Trademark may be a word mark. It may be a device also. It may be a logo also, right? There are overlapping on trademark and copyright. But अगर आप simple एक mind में रखेंगे कि जो copyright है that should be for your originality, artistic work, कुछ इस way से होना चाहिए और different categories हैं. Like a word mark, वहाँ पे trademark में word mark जो है that is also a trademark. ठीक है? यहाँ पे एक word को लेके आप copyright नहीं करा सकते.
Okay, thanks, ma'am. So we have a question from Mr. Rajendra. What are the economic rights and moral rights? What happens in case of assignment? Ma'am, you're on mute, ma'am. Dr. Prithpal Kaur, you're on mute first. Yeah. Oh.
Should I take that?
Yeah, Dr. Raj.
Okay. Okay. So when we are talking about economic right, here it means that we can exploit those right and earn profit out of it. Like if we have written one book, right? We are having economic right, which has been mentioned under section 14, which says that we can make copies of it, we can reproduce work, translate work, other things. Okay, in that way, when we are doing that, automatically we are commercially gaining out of it. So those are identified as an economic right. And moral rights are those which cannot be assigned at all. Okay, remember that those rights has been given to original work, the first four category: artistic, dramatic, musical, and literary work. To these work, these moral rights has been granted, and that is what it says. It's an original expression of an author. It's coming within us, and whatever we are writing about, whatever we are drawing about, making drama, writing about drama, anything, that is our original expression and not copied from anyone, and therefore we have copyright into that. And when we are identifying, means we have moral right, it means that you cannot use your name, or just imagine that if I have written one story for you and under some contract, and that has been given to you, and then what I'm doing, I am assigning my copyright to you, but moral right, that I have written, that my name will always be there. Take the examples of some painting. Painters always write their names, so their name, that right of integrity will always be there. His name, his reputation is attached with that particular artistic work. And uh, right to paternity and right to integrity, these are two rights which has been identified under copyright law as a moral right. That means we are not supposed to change that name, one thing, and we are not supposed to make any distortion, mutilation, or any changes with respect to that work. That is the second right. Okay, these are the moral rights, and without my permission, if I have written certain story without my permission, you are not supposed to make changes into it. If that is artistic work, then also if it is mural, you are not supposed to make changes into that. These are the called as moral rights. Okay, and those are not assignable. Those will always with author only. I may shift, I may transfer, I may assign my work to you. You will become owner of it, but you are not author. I am owner. So moral right are always attached to author only. I have given answer to other questions. Yes.
I just want to add something.
Yes.
Moral rights were first recognized in France and Germany before they were included in the Berne Convention for the protection of literary and artistic works in 1928, basically. Canada recognizes moral rights in its copyright at that time. That was just an addition for the knowledge I'm sharing with you.
Sure, ma'am. So this has been a fabulous session, absolute fabulous session. I think our most well-attended session in at least a year. I'm really thankful to Dr. Prithpal Kaur and Dr. Ragini for such an engaging session, and thank you so much to the audience also for all your questions. Let's keep the discussion going. I've given the link of our LinkedIn page, and if any question has been unanswered, you can post it there, and we will get back to you. I would like to also thank our hosts, ASSOCHAM, Parul and Preeti, who have been with us during the webinar and have moderated it so well. Thanks to my partner in crime, Dr. Himang Shah. It's always a pleasure, being part of these webinars, and thank you so much. So thanks all. Thanks once again to our brilliant speakers. Thanks to our brilliant audience who were so engaged throughout, and thanks all to ASSOCHAM and Dr. Himang Shah for your participation in the webinar. So I'll now close the webinar and look forward to joining another webinar very soon. And Dr. Ragini and Prithpal Kaur, we would like to invite you for our subsequent webinar again. You have been very engaging speakers, very engaging speakers. I think
Thank you,
everyone
sir.
has
Thank you
gained
so
a lot.
much.
Thank you
And
so
it's
much.
a love to
Thank
be
you.
part of.
Yes, thank you
You.
so much. Thanks a
Thank you,
lot.
sir.
Bye.
Bye.
Okay, bye. Bye,
Bye.
ma'am.
We are closing the
Thank you
webinar.
so much, sir.
Thank you so much. Thanks.